Hello everybody. The Indian democracy is held strong by three cornerstones: the legislative, executive and the judiciary. The judiciary has been held in very high regard by the common man from the old age itself. The judiciary is the guarantor of justice, the protector of the common man, and in times of need, it has stepped in to advise the legislative, criticize the executive, and even in consultations with the President of India. But what happens when the judiciary itself comes under the spotlight for the wrong reasons? Yes, I am talking about the recent media reports regarding the Allahabad High Court judge and his burned notes scam. So in this video, let me take you through a quick ride on the news reports regarding the Allahabad High Court judge, impeachment proceedings that are soon to be followed, and why and how the Supreme Court protects the Constitution of India and the common man. On March 14th, a fire was reported in the official residence of then Delhi High Court Judge Yashwant Varma. Following the fire, burnt currency notes were recovered from the outhouse storeroom of his residence. This media report instantly brought the judiciary and the judge under public eye. Of course, it raised questions on who will check the judge himself. The Supreme Court initiated an in-house Enquiry committee to deal with this matter. The committee consisted of 3 members and they submitted its report in May 2025. The committee found the judge guilty of serious misconduct, saying that the said cash was recovered from the residence under his control. And they also criticized him for his flat denial and bold conspiracy theories. In the meantime, the judge was transferred back to his parent High Court, the Allahabad High Court, where he was assigned no judicial work. Based on the Inquiry Committee's report, Chief Justice of India Justice Khanna recommended the Parliament to initiate his removal proceedings, even though the judge during the time of inquiry willingly complied with the Inquiry Committee, has raised serious allegations against the committee recently. He has called this in-house Enquiry Committee as an extra-constitutional legal mechanism and said that it has no constitutional authority, since the judge can only be removed by initiating proceedings in the Parliament and not in the Supreme Court itself. But the Supreme Court has refuted Justice Varma's claim, saying that the in-house Enquiry Committee is a valid procedure to maintain the legal integrity of the judiciary and is a valid mechanism to maintain the clean image of the judiciary. So, now the matter has reached the Parliament and we know that in a few days the Parliament will start impeachment proceedings against Justice Varma. Even though previous Chief Justice of India had advised Justice Varma to resign before these proceedings begin, he refused to do so. So, let's now see how does an impeachment process actually work. The Supreme Court is held in a very high regard, as we all know. So, the process to remove a judge is also very thorough and a very strict procedure. It is given clearly in the Constitution how to remove a Supreme Court judge and on what grounds. This process is called the impeachment process, and a judge can be removed only on 2 grounds: proved misbehaviour or incapacity. Proved misbehaviour means the judge has done something seriously wrong, like the misuse of power or corruption. And incapacity means he is unable to hold his office and perform his daily duties due to any physical or mental condition. So, here the judge has faced serious allegation of proved misbehaviour, suggesting that the burnt currency notes are a form of corruption. How does an impeachment process actually work? The impeachment process, or the process to remove a judge, begins in the Parliament. To be admitted in the Parliament, This has to be signed by at least 100 members in the case of Lok Sabha and 50 members in the case of Rajya Sabha. In the present scenario, 146 members have signed a petition in the Lok Sabha to initiate removal proceedings. The Speaker then decides whether to accept or reject this petition. Here, the Speaker Om Birla has recently accepted the proposal and has constituted a committee to inquire into these allegations. In the present scenario, this committee consists of Supreme Court Judge Arvind Kumar, Madras Chief Justice Manindra Mohan Srivastava and Senior Karnataka High Court Advocate B.V. Acharya. This committee goes seriously and in deep into these allegations. It thoroughly investigates the case, listens to the witnesses, collects evidences, and even gives the accused judge a chance to present his defense. After investigating thoroughly, if this committee finds that the judge is not guilty, then the proceedings stop then and there. But if it is found he is guilty, then the committee submits its report before the Parliament. And now comes a crucial stage where the Parliament decides on it. Based on the committee's report, both houses of the Parliament separately discuss, debate, vote on whether to accept the committee's report and remove the judge. This vote is not a simple majority vote. This vote is a special majority vote. And what is a special majority vote? A special majority vote means that a majority of the total membership of the House and a majority of 2/3 members present and voting. Each House has to separately clear this majority, and after passing by both houses of the Parliament, it is then submitted to the Honourable President of India. Based on the report submitted by the Parliament, the President then issues an order asking for the removal of the said judge. An interesting fact is, so far, none of the judges have been removed through an impeachment proceedings. Earlier, Calcutta High Court Judge Soumitra Sen and Supreme Court Judge V. Ramaswamy had faced some allegations, but before initiating an impeachment proceeding against them, they had willingly resigned from their respective posts. So, let's see in the coming days how this inquiry committee and the subsequent impeachment proceedings will go on. In the meantime, let me also go through a quick outline on why the Supreme Court is powerful, how it is powerful, and what are the rights enshrined in the Constitution and what are its duties to the common man. Now, let's see quickly about the Supreme Court of India. The Indian Constitution has designed an integrated judicial mechanism with the Supreme Court at its top. The Supreme Court is a successor of the Federal Court of India established under the Government of India Act 1935. Judges of the Supreme Court are appointed by the President of India after consultation with judges of the Supreme Court and High Court as he deems necessary. So, what are the qualifications of a judge of Supreme Court? He must be a citizen of India, first of all. Secondly, he must be a judge of any High Court of India for 5 years, or an advocate in High Court for 10 years, or a distinguished jurist in the eyes of the President. Here, interestingly, we can see that the Constitution has not made any requirements regarding the minimum age for a Supreme Court judge. Now, the Supreme Court judge holds office until he attains the age of 65 years. He can also resign any time by writing a resignation letter to the President. Also, he can be removed by an impeachment proceeding, which we have already seen. So, here we see that they have been provided with the security of tenure. The Constitution has provided extensive jurisdiction and vast powers to the Supreme Court. What are the powers and jurisdiction of the Supreme Court? Here is a quick view. The Supreme Court has an original jurisdiction in cases of dispute arising between the centre and the states, or in case of centre and one or more states and one or more states in the other party, or in case of two or more states dispute. The original jurisdiction means that the Supreme Court can hear these disputes in the first instance and not by way of appeal. The Supreme Court is the protector and guarantor of the fundamental rights as enshrined by the Constitution itself. So, it means that the Supreme Court can issue writs to protect the fundamental rights of the common man. These rights are habeas corpus, prohibition, mandamus, certiorari, and quo warranto. Also, the Supreme Court has an appellate jurisdiction. It means that it primarily hears appeals from disputes and settlements of the lower court judgments. These appeals range from constitutional matters, criminal matters to civil matters. The Supreme Court also has an advisory jurisdiction. Under Article 143 of the Constitution, the President can seek its opinion from the Supreme Court in two cases. In the first case, it should be regarding a law or fact of public importance which has arisen or which may arise. In this case, the Supreme Court may or may not give its opinion. The second case is regarding any dispute arising from a pre-constitutional treaty or enactment. And in this case, the Supreme Court has to tender its opinion to the President of India. The Supreme Court is a court of record. It means that all the judgment and enactments and proceedings of the Supreme Court have evidentiary value and it is recorded. That is why you might have observed that some judges, while giving the judgments, refer to previous Supreme Court judgments and cases because they are all recorded and have evidentiary value. Very importantly, the Supreme Court has the power of judicial review. It means that the Supreme Court can review and examine the constitutionality of legislative enactments and executive orders of both central and state governments. So, if the court finds them to be unconstitutional or invalid, the said law or enactment cannot be enforced by the government. Apart from all this, the Supreme Court also has some other powers, like it is the deciding authority when a dispute arises in the election of the President or Vice President of India. It can also inquire into the conduct and behavior of the UPSC members. We also see that the Supreme Court is a self-correcting agency. It means that whenever it finds its previous judgment to be invalid, it can correct itself and review its own judgment. So, we find that it corrects its own mistake. Finally, we can see that the Supreme Court is the ultimate interpreter of the Constitution. You might have also observed that whenever something related to the constitutional matters is being brought in the media, the government ultimately goes to the Supreme Court for its advice. Because the Constitution of India is like a Bible and every word in the Constitution has utmost importance. Who better to guard it than the Supreme Court itself, which acts as an impartial agency? Did you know that to ensure the impartiality of Supreme Court, there are certain checks and clauses? First of all, as we have seen, they are appointed by the President and their removal is a very tedious process. So, it doesn't have any political influence for their appointment and removal. Secondly, we can see that tenure and conditions of service are fixed and cannot be changed. The Parliament cannot curtail its jurisdiction. However, the Parliament may extend the jurisdiction of the Supreme Court. And the Supreme Court judges are barred from practice after retirement. This ensures that they do not give any favourable judgments in the hope of future benefits. So, dear friends, I hope we have got a very good idea about the recent proceedings, impeachment, the Justice Varma case, and how the Supreme Court stands tall amidst all this clumsiness. To maintain its untainted reputation, it's necessary that members, that is, the judges, keep up the record. And as and when, if at all, these members fail to maintain their responsibility, there's a system in place to check them. Let's hope that the Supreme Court comes out of all these controversies and allegations and is able to maintain its clean image so that we as common people of this land can have faith in this country in the very adverse circumstances and in any political situations. Thank you. Bye-bye.